Good afternoon, everyone, and welcome from wherever you are joining us from. The session is dubbed the new ACHPR Rules of Procedure, Losses and Gains. As you may already be aware, in June 2018, under paragraph 5 of the African Union, Executive Council declared that the African Commission only had independence of a functional nature and not independence from the same organs that created the body. This is untrue because, as we all know, the African Commission was not created by the AU organs, but by the African Charter. Hence, it derives its power and mandate from the Charter. So this decision, which is commonly referred to as the Decision Chan 15, also under paragraph 8.1, requested the African Commission to address the ambiguities of its status in the rules of procedure within the framework of its ongoing revision of the rules. So this session, dubbed the new ACHPR Rules of Procedure, Losses and Gains, seeks to explore the impact of the 2020 Rules of Procedure in the advancement of human rights in Africa. Our speakers today are Dr. Satang and Professor Viljoen, Frans Viljoen. Dr. Satang is a postdoctoral fellow at the Center for Human Rights, Faculty of Law, and she's also a member of the panel of experts of the Initiative for Strategic Litigation in Africa, ISLA. She holds the LLD and LLM degrees in human rights and democratization in Africa from the University of Pretoria, and the LLB from the University of Ghana. Her research includes a broad range of issues related to international human rights, women's rights, democracy, and constitutionalism. Professor Frans is not a stranger to most of us who are tuned in. Is the director for the Center for Human Rights in the Faculty of Law at the University of Pretoria. His research areas are in international human rights law with a focus on the Africa Regional Human Rights System. He is also the editor-in-chief of the African Human Rights Law Journal and the Global Campus Human Rights Journal. He has been involved in advocacy campaigns and litigation before the African Union Human Rights Body and has published widely on international human rights law. I am your host. My name is Ramtu, and I'm the coordinator for the CIAC. So for the purpose of this session today, all of you are on mute. We will allow the speakers to make their presentation, and then we'll open it up for plenary after their presentations. In the meantime, if you have any questions or comments to make as the presentations are ongoing, kindly use the chat box. So to start us off, it's going to be Professor Frans, who is going to give us an introduction to the 2020 ROPs and just set the landscape for this conversation. And then we'll invite Satang to come in with a more specific aspects in terms of the losses and gains. So Professor Frans.
Thank you very much, Marie, and welcome to everyone. Good afternoon, I'm sure, for most of us on the continent. Yes, I think I will speak to two main issues, and that is the status of the Commission. I think Marie introduced that issue, and also some remarks around the communications aspect, and Satang will speak to everything in between. So I think for me, a starting point is we have the 2010 rules, and we have now seen them being replaced by the 2020 rules. So in a sense, one asks yourself, if you compare these two sets of rules, what happened between 2010 and 2020? What was the major events that somehow should impact on the way that the rules look differently? And I think Marie pointed to this one aspect. Let me remind us that in 2010, so that's the beginning of this decade, the Coalition of African Lesbians applied for but was rejected in terms of its application. So its application for observer status was rejected. In 2014, they applied again. 2015, they get to be admitted as observers before the Commission, but the Executive Council comes back with a decision to say, no, this is unacceptable in terms of so-called African values. The Commission has to undo that decision, that granting of observer status. However, the Commission, in a sense, pushes back, but eventually in 2018, the Executive Council comes up after a retreat between the Commission members and the members of the PRC. The Executive Council comes with this decision 1015, the famous decision that we referred to, and it basically puts the Commission on terms and says you have to now withdraw the status, and it goes much further than that. It talks to issues around the Commission's status. So as we know, the Commission eventually followed that directive from the Executive Council. It withdrew the status, and then now we look at how that Resolution 1015, among others, had impacted on the rules of procedure of 2020. So the first day then is rule number 3, rule 3 of the 2020 rules, which speaks to the mandate and status of the Commission. So it states unequivocally that the Commission is autonomous, and it is an autonomous treaty organ of the African Union, but based under the African Charter. Now, it is interesting to all of us to look back and see, but that was also there in the 2010 rules. The 2010 rules also said the Commission is an autonomous treaty body. But the difference here is interesting, because in 2010 rules, it's just one-liner, the Commission is an autonomous treaty body. But in the 2020 rules, we find 7 sub-rules in which all of this is being unpacked. And I think it is important that it is being done. I think it is important that the Commission reaffirmed its autonomy as a treaty body. So it is this ambiguity that it is both a treaty body and an AU organ that is seemingly the kind of a tension that we need to be resolved. I think it is important that the Commission didn't go to the language of independence. Because Mary also pointed out that in that Resolution 1015, there was this distinction between functional independence and then independence within the institution of the African Union. I think that is quite fraught with difficulty, because in some sense, I think we have to concede that there is some relationship of limited dependence of the Commission on the AU structure within which it functions, in terms of the election of members, in terms of the budget, and so on. So I think it is wise for the Commission to have stuck to the language of autonomy. For me, autonomy, I mean, from a philosophical sense, autonomy is to be in an independent mind, not to be coerced in mind or in any other matter by external forces. So that's the affirmation that we find here in the rules of 2020, the affirmation of autonomy. But in the sub-rules that are added in the 2020 rules, the Commission refers to Article 30 and Article 45 of the Charter, basically saying, but our autonomy is rooted in the Charter. Our autonomy is rooted in the fact that the Charter created us as an autonomous body, and that we've been given competencies to interpret the African Charter, competencies in terms of functioning as an effective supervisory body. And these bolster the idea, the notion that the Commission should be autonomous in its functioning within the framework of the African Charter in the first place, but then broader within the framework of the African Union. So many of the sub-rules of Rule 3 speak to this aspect. But in sub-rule 3 sub-2, we find this, that it says, in accordance with AU Assembly resolution decision, the African Commission is an organ of the African Union. So this is where the kind of reconciliation between the two, an organ of the AU and a treaty body that is autonomous, comes in. Why is that in there? You would recall that in the AU Constitutive Act, the Commission is not listed as an AU organ. I mean, we have the Assembly, the ECOSOC, and the other institutions like the Executive Council and so on, but the Commission is not there. And that kind of ambiguity led to the decision by the Assembly early in the Durban meeting when the AU was really founded. The decision was taken that the Commission should be seen as functioning or operating within the AU. So that decision fell short of saying the Commission is an AU organ. It said the Commission functions within the AU. It functions, in a sense, as an organ, which is a slight difference. Now, what we see here in Rule 3 is that the Commission now, in its rules, affirms that it is an organ, that is an organ of the African Union. I think that is in line with what the political directive sense had been, in line with the AU thinking around this Commission. There are a number of decisions by the AU to point the Commission to clarify its status as an AU organ. But I think if we read Rule 3 in its totality, clearly the focus here is on the autonomy of the Commission as an autonomous treaty organ, but it is at the same time an AU organ. So I think the attempt in Rule 3 is to kind of reconcile this, to concede that the Commission is an AU organ, but that it is autonomous, and its autonomy lies in the rootedness in the African Charter and the competences, the function that it is understood and accepted to fulfill within the AU structures. So I move then to the issues around communications, which is really towards the latter part of the rules. And I want to kind of, again, look at perhaps defects, issues that arose from 2010 to 2020, and see what the rules have done now, how the revised rules look perhaps different. The first issue, as always, I think the issue is one of delays. There has been consistently a problem with the delays in the finalization of communications on the side of the Commission. So what we see that the new rules do in Rule 115, I think quite significantly, the issue of seizure is being addressed. Now, in the old rules, in the 2010 rules, the seizure was a process that the Secretariat had to investigate, see if all the elements are there, and then the decision to be seized or not was completely for the Commission. So no matter could go forward until the Commission had taken a decision to be seized. Now, oftentimes the seizure decision is not very controversial. So the new rules give the competence to the Secretary to investigate and take decisions on seizure, finalize decisions on seizure. But it's only when there is doubt that this matter now goes to the Commission, and the Commission as a whole will decide on seizure. So I think this can really almost eliminate a whole phase, because usually the Commission would table a matter for seizure, and only after that table it again for further phases. So this could eliminate the seizure phase before the Commission for many, many cases, unless there is some form of doubt really in the eyes of the Secretary. The second element in terms of the delay is that the Commission in Rule 116 seems to want to conflate the admissibility and merits stages. Now, clearly, again, if you have three distinct stages of seizure and then later admissibility and later the merits, this leads to a certain amount of inevitable delay. I'm not going to talk to the detail of this, but if you look at 116, Rule 116 in the new rules, the complainant is now supposed to bring the case forward on both the admissibility and the merits. So there's an attempt to at least create some synergy in the process forward, in terms of not necessarily having all these different phases in the life of a communication. The second big issue that I think had arisen always is that of bias, or allegations by states that commissioners are biased. Now, I think we've seen that coming very clearly to the fore when Eritrea alleged that the Special Rapporteur on Freedom of Information, freedom of expression, access to information had been expressed herself as being biased by her writing in a preface to a CSO report, actually a report by the Center for Human Rights. But the issue was really that had to be determined. Is she biased, and therefore should she recuse herself from the process of hearing a communication pertaining to Eritrea? So again, I was quite taken aback to realize, because one doesn't always study the rule so closely, that the rule that deals with this issue was exactly there in the old rules as well, 2010. So in terms of the 2010 rules and the 2020 rules, the issue of bias and recusal really is similarly provided for. The only difference is that there is one clause now that is added in terms of the 2020 rules, which gives more flexibility. If one looks at 2020 Rule 94, there is a ground that is added, and that is that the recusal on the basis of impartiality can be based on any other reason that shows impartiality that is capable of being lead to an adverse effect. So I think the lesson also of that whole sequence of events was that perhaps there should be a broadening of the limited grounds, not very limited, but to the extent that was required. A third element in terms of communications that I briefly want to touch on is that of states alleging often in those decades before and also between these 2010 and 2020 that the process against them is unfair, that they've not been given an opportunity to give full argument, submissions, and so on, and that often related to the cooperation of these states within the process. So I think it is very suitable that in the new rules we find Rule 92 that talks of the duty to cooperate with the Commission. So that is a duty on the parties to a communication to fully cooperate. So we know that there are timelines and ways in which clearly the rules require states and other parties to cooperate, but this is an overarching obligation to cooperate and make it very clear that both the state and the complainant have to cooperate at all stages, in other words, to be part of the process fully. A fourth element that I would point to very briefly is that of the participatory nature of the process before the Commission, the complaints process. And I think although the previous rules mentioned amicus curiae, the possibility of an amicus bringing a brief, this is now being much more elaborated, expounded upon in the 2020 rules. I think that is very salutary. It puts emphasis on this. I think very briefly, the amicus brief can come before the Commission in two ways. An amicus can apply to be admitted as amicus, and that would be that you have to basically show that you can bring something that would be of benefit to the Commission, something perhaps novel. So Rule 104, sub-rule 3b says the amicus must show the contribution that it can make, the amicus can make to assisting the Commission, so that it's not merely repeating what parties have said. What is the contribution? The Commission can then admit a requester as an amicus. The other angle or avenue is that the Commission can also, on its own initiative, approach a CSO or an entity to become an amicus before the Commission. I think that it's interesting. There's some kind of a leap, I think, towards transparency in Rule 105, sub-rule 7. It says that amicus briefs admitted by the Commission may be published on its website. So I think that shows that the Commission is thinking about transparency. But I think it's also transparency that is the problem often to amicus being able to make their briefs or write up their arguments, because if one is not aware of a case, then clearly one is not able. If one is not aware of the nature of the arguments by the parties in the case, you do not know how to complement the arguments of the parties. So it is advisable that there should be some form of disclosure without disclosing the details of cases about what cases are pending before the Commission, so as to facilitate the amicus briefs being presented. This has to be distinguished from the third parties with a direct interest. So there's this distinction on the one hand, third parties with a direct interest can also come and make representations before the Commission, and they are distinguished from amicus curiae, which are then defined in a way that perhaps is problematic, because the amicus curiae are defined as parties that have no interest in the outcome of the communication, no interest in the outcome of the communication. whereas perhaps that should be understood as having no direct interest in the case, but in the sense of having an interest in a human rights advancement sense, clearly cannot be a reason to exclude an amicus. In other words, if an amicus wants to see that human rights be advanced in a particular way rather than the benefit that accrues in a particular case, I think this should not be a reason to exclude an amicus. I'm coming close to my end. There's also the issue of reprisals. Clearly an issue that have come up in the time between 2010 and 2020 had been reprisals of victims, measures taken to intimidate perhaps people involved in cases, complainants bringing cases. Now, although the previous rules had some mention of such measures that need to be taken by states to protect, for example, in Rule 99 and Rule 100, in the new rules, in the 2020 rules in Rule 107, all of this is compacted, and it's a very strong statement around protection from reprisals. It's more expansive. It places a very clear duty on the state parties to ensure that these kinds of reprisals do not take place, and that is clearly an advance. The last issue I want to touch on is that of the complementary relationship in terms of communications between the court and the Commission. Now, we know that in the 2010 rules, there were quite a number of clear grounds that could lead to a referral from the Commission to the court, Rule 118 in the old rules. It is interesting that the only explicit ground for referral from the Commission to the court in these 2020 rules is when the Commission is dealing with a case and before it finds admissibility, it refers the matter to the court. So we find that that is being explicitly recognized as a ground for a seizure of the court in Rule 130 of the new rules. The Commission may, before deciding on the admissibility of the communication, refer the case to the court. In my view, that cannot be the only reason why the Commission can refer a case to the court. Although the other reasons are not made explicit, the mere fact of the complementary relationship between the Commission and the court must imply that the Commission may also refer, for example, cases that have been decided on the merits, cases where Commission has given recommendations to states and they have not complied with those recommendations. Those, by virtue of the complementary relationship between the two institutions, those must still be able to be referred to the court. And I think that is covered somehow in Rule 128, which refers to this kind of general complementary relationship between the Commission and the court. So in summary, I think that clearly from what I said, we can see that there are a number of advances, focused maybe on the positives that we see that could be utilized to make the promotion and protective functions of the Commission more effective. But I think that Satang will bring out some more of the negative elements. Thank you.
Yeah. Thank you, Prof, for that introduction. In your presentation, you have touched on the rule number 3 and additional provisions that have come with the 2020 ROPs. And you have also touched on the communication, and you have highlighted some of the 3 key aspects around completion of the admissibility and merit stages, and also additional clauses that give more flexibility to commissioners around bias and recusal, and also Rule 92 that stipulates a duty for states to cooperate with the Commission. And you also highlighted the fact that there's increased participatory nature with the 2020 ROPs, and you have mentioned the 2 processes on amicus, where one can apply to provide an amicus brief, or the Commission can approach for can approach organizational individuals for an amicus brief. And also you made a distinction between the third party and amicus brief, and you finished with reprisals and the complementarity relationship between the court and commission. So at this point, if there is any participant who has any comments or questions specifically addressed to Prof, kindly make a note of those, and then we'll have them addressed during plenary. So at this point, I'd like to invite Dr. Satang to speak on everything in between, as Frans had mentioned at the beginning of our session. Dr. Satang, the floor is yours.
Hi, Maria. Hi, everyone. Thank you for having me. As you rightly stated, Frans Professor Frans sort of laid the groundwork in terms of the new rules of procedure, and I'll try to tease out, not comprehensively, but at least tease out some few things as well. I'm supposed to share a PowerPoint. I thought it would make my life easier. Okay, give me a second. Okay. Okay. Are you guys seeing anything? Yes, no? No?
Sorry, I don't. Sorry. No.
Okay. no, that's fine. I mean, I can just do the just do it without the PowerPoint. But it was easier in terms of just highlighting the rules. I mean, I guess Professor Frans is more than when it comes to okay.
It's there now, Satang.
It's there?
Yes. Oh, no, it's not. Sorry. No, I'm wrong. I did something else that came up.
Oh,
no.
Okay.
No,
but my face is there. Okay, it's fine. I'll just look at my computer and just present it. Anyway, it's fine. Okay. So in terms of some of the things I wanted to add in addition to some of the things that Professor Frans already spoke about is issues around the code of conduct, the sessions of the commission, reports of the commission, the role of national human rights institutions and non-governmental organizations, and probably tease out some questions as well. In terms of the first issue around the code of conduct, Rule 11 of the rules of procedure, the 2020 rules of procedure, uses the operative term shall to require members of the commission to observe the principles and codes of conduct that are stipulated in the rules that govern their services, as well as relevant provisions of the AU staff rules and regulations. Just to state that the term relevant is actually not defined, which probably makes the provision a little bit ambiguous as well. I think generally this is a good rule, but I think one of the issues around it, or a shortcoming around it, is whether there's any possibility in certain circumstances for the commissioners to be treated as staff of the AUC, which might obviously affect their exercise of their independent mandate, as well as being free from political interference and so forth. However, if you look at Rule 11 sub 2, it actually clarifies that in the case of conflict, the specific rules as applicable under these rules shall take precedence. So in the case that there is likely conflict, then the rules will take precedence, which is, in my view, a good way of trying to address this particular issue. In terms of the in terms of the sessions of the African Commission, there are several rules in terms of that, but specifically in terms of Rule 27 and 28. 27, for instance, does maintain the rules, the 2010 rules 25.1 and 25.2 on the general principles of the Commission having sessions. However, it does add two other sub-rules. One is the one on live transmission of session proceedings where possible, that is Rule 25.3, and 25.4 on the adoption of communique for the public at the end of the session. I think this is particularly important, especially in the times of COVID-19 and the pandemic, considering the fact that during the last ordinary session of the Commission, it was held via Zoom and people were able to access this virtually, as well as the extraordinary session that was held in June, July as well. So in terms of, this seems to be very timely in terms of providing an opportunity to live transmit sessions where possible as well. I also wanted to point out that Rule 28, for instance, also does provide for and increases the sessions of the Commission now from 2 to 4 each year, which is timely. Probably on one side, I think it's like a double-edged sword. On one side, it is timely because obviously in terms of the that there usually is not enough time for the Commission during the sessions to actually cover the very extensive program of work, especially looking at the different special mandates and mechanisms and so forth. But I think on the other hand, especially in terms of civil society participation during the session, especially in terms of dwelling resources and so forth, it might also be a little bit negative as well in terms of whether, if, for instance, there are 4 sessions in the year, whether NGOs will be able to participate in these sessions as well. 28.2 is also important, just to highlight a bit, that in terms of convening sessions of the African Commission, for instance, now it places it in the hands of the chairperson of the Commission in consultation with other members of the Commission, and does, and I think this is important, especially in terms of strengthening the independence of the Commission, it removes the requirement for consultation between the Commission chair as well as the AU chair, under which were previously provided for under Rule 26.2 of the 2010 Rules of Procedure. I think generally this is a good provision, as I said, especially in terms of the fact that the AUC chairperson should probably not have the integral power in terms of the rules to call it off or postpone or delay it as well. And going further in terms of Rule 28.3, which retains the Rule 26.3 of the 2010 rules, where in exceptional circumstances, for instance, the chairperson of the African Union Commission may change the opening date of a session in consultation with the chairperson of the Commission. In terms of whether this is a compromise, probably, but it's also a good thing, as it does limit the power of the AUC chairperson to possibly alter dates, and only in exceptional circumstances, and always in consultation with the chairperson of the Commission. Still on sessions, as I said, sessions are a little bit long. In terms of Rule 29 on extraordinary sessions, the wording has actually changed from shall to may, and I guess this comes very timely, especially in the situation of the petition in Kenya right now, in terms of debates around whether shall. But anyway, I digress. Anyway, so in terms of Rule 29 on extraordinary sessions, now the Commission has the option to actually hold extraordinary sessions, and rather than making them compulsory, which removes the obligation from the Commission's chairperson to actually set dates in consultation with the AU chair, and remits consultation only to members of the Commission as well. All of this is especially in terms of strengthening this idea that this is a positive decision and positive rule, as it does provide the platform for the Commission to actually hold extraordinary sessions without involvement of the AUC generally. I also wanted to quickly highlight Rule 30 on the venue of sessions. So this has actually changed the title from place of meetings from the 2010 rules to now venue of sessions. So Rule 30 sub 3 is particularly important, as the state agreeing to host the session shall guarantee the unfettered participation of individuals attending the session, and especially for NGO participation during the session, as well as holding the NGO forums that prior to the session themselves. I think this is important, especially in light of past situations where, for instance, particular state parties which have hosted the African Commission session have actually denied NGOs visas, have actually denied NGOs visas, have also, as a result as well, not actually provide, basically in terms of NGOs participate in the registration process and so forth. But I do think that, especially with regard to this rule, there is the rule didn't go so far as the Commission did not, I think, in a sense, actually reiterate the importance of the state party that is inviting them to hold a session, not to be seen as a human rights violator in accordance with obligations under the African Charter. And I think this is important because, I mean, if a state party is inviting the African Commission to host a session on human rights, the state should not be seen ideally as a state that really denies human rights or violates human rights, or is seen to be a violator of human rights generally. Rule 30 sub 4 also does address the issue around states that actually offer, for instance, to host sessions of the Commission but later change their minds, especially in terms of removing barriers for NGOs coming to the session, which is very important, especially within this context that we are talking about, as well as meeting obligations toward commissioners and making translation and interpretation data services available in all AU languages. So really Rule 30 sub 4 also really tries to address this issue, especially in terms of this idea that inviting state parties that want to host the Commission sessions should ensure that they put in place all the required financial, human resources, as well as the conducive environment for civil society participation in all the processes and procedures of the African Commission fully. Just to also highlight quickly the last thing on sessions in terms of notification of the opening date of sessions. So Rule 31 sub 1 does reduce the notice dates of the ordinary sessions from 60 to 45 days. And this is important just to highlight, especially in terms of civil society preparations and so forth, to attend sessions in Banjul or to attend sessions in other places as well. And just to say also that for Rule 31 sub 2, it also changes the wording with regard to the notice period for holding extraordinary sessions from as soon as possible before the beginning of the session to as soon as practicable, which is vague and doesn't really allow for much planning around those dates as well, generally. Okay, so in terms of sessions, that's it. And just to quickly go into the reports of the Commission, Rule 63 does require the Commission to submit its report to the Assembly and to publish the report on the website only after it has been considered by the Assembly. That is that the Commission has been facing vis-a-vis its relationship with political organs of the AU. I'll actually come back to this as well, especially in terms of just teasing out some few questions and issues arising from this particular rule. And finally, in terms of the role of national human rights institutions and non-governmental organizations, Rule 71 of the 2020 Rules of Procedure now amends 69.1 of the 2010 by really laying out the legal basis for granting of affiliate status to NHRIs and also allowing those without affiliate status to attend sessions as observers. This is good, especially in terms of addressing the issues around state queries into the legal basis for granting of observer status and so forth. But I think one of the one of the questions that might arise out of this will be whether the Commission's decision in terms of reasserting its independence through this rule will be deemed as contrary to the decision of the AUC, which did require or request the Commission to ensure that its granting of observer status is actually in line with existing AU accreditation criteria, and I quote, which take African values and traditions into account. There have been quite a lot of debate around this phrase, especially in terms of the crisis that arose in 2015 with regard to the AU Executive Council directing the Commission to reverse its decision of according observer status to the Coalition of African Lesbians. In terms of this rule also, I just wanted to lastly point out that it also introduces Rule 72 sub 3, which actually strips civil society organizations with observer status of that particular status if the Commission does consider that such an NGO or such an observer can no longer fulfill the criteria or default on its participation and engagement with the Commission. This actually raises a little bit of questions, especially in terms of NGO participation in the processes of the African Commission, especially considering generally the inability of civil society to engage with the Commission, or in terms of constraints such as financial barriers in terms of submitting its activity report due to probably dwelling funding, as well as more importantly, and I think this is an ongoing conversation in terms of the shrinking civil spaces globally, but also in Africa, which can further marginalize civil society voices as well. And also to say that this rule doesn't seem to comply with the principle of natural justice, as it does not seem to make any provision on recourse that NGOs who are subject to such measures can actually take. So what happens if such a status is taken back? Will the NGO then have to go back to the drawing board in terms of reinstating its status, whether it will have to be starting their getting the observer status all over again, which we know that it's a long process, or whether there might be other measures to take in terms of addressing the issues of why this particular NGO couldn't really address the issue. And finally, in brief, Professor Frans highlighted some of the rules, and I think today as well there were two other panels earlier than this one in which the 2020 rules of procedure were looked at as well. I think generally there are quite a number of positive developments that really allow for NGO participation, smoother processes, and affirms the African Commission's independence. But as I said, there is really need, especially in terms of putting in place guarantees for NGOs, the right to be heard in reinstating their status without having to reapply for observer status and so forth. But there are also quite a number of shortcomings as well in terms of some of these rules. And I think one of the key question, especially in terms of the presentation of the report, the submission of the report by the Commission to the AUC, is especially in terms of consideration of the report, is questions around what consideration means, whether that means that the Assembly, for instance, has the power to request the Commission to include or exclude certain things in the report, whether the AUC will have the power to direct the Commission on how it should apply its rules in the making of decisions contained in the report, and whether they can also have the power to withhold the release of the report until it reflects the wishes of the Assembly. For the 2020 rules of procedure doesn't really address these issues, and I think generally for NGOs participation, for also ensuring the independence of the Commission, generally these are remaining questions that needs to be addressed, which are not addressed in the rules of procedure. So there is really need for the platform for civil society organizations to think, debate, engage, and strategize in terms of addressing these issues. Thank you.
Thank you, Satang, for your presentation. And in your presentation, you have touched on everything in between, which includes the code of conduct, the sessions, and in the sessions you highlighted them, which are some of the provisions, especially around the extraordinary sessions. And you touched on the reports of the Commission, the role of NGOs, and NHRIs, and you highlighted the fact that the 2020 ROPs allow for NHRIs daughter affiliate status to join the sessions as observers. And also you went ahead to highlight the fact that a downside for NGOs where the observation status is taken away, the new rules do not provide provisions for recalls. And also you finished your presentation by highlighting some aspects which you feel would have been addressed by the 2020 ROPs but have not been addressed. So at this point, I would like to go to plenary, and there are some questions which have already been submitted. I'll just go through those questions as to start the plenary session. And the first one, Frans, I'm not sure if you're able to see the questions that have been posted. Yeah, the first one is a bit long. I think it's addressed to you. So you can take that. And the second one also wants to hear your view on whether whether you think the 2020 ROPs in general are an improvement from the 2010 ones, and what would you have loved to see included which is not covered. And then the third one is addressed to you, Satang. It's around the extraordinary sessions. It asks if it's an improvement to have 4 extraordinary sessions. And there's a comment that says, I've always thought that the term extraordinary is being used or misused. Does convening 6 times in 1 year add anything useful to the conversation of promoting and protecting human rights in Africa? I ask because I have this feeling that you are trying to copy what the court is doing, which is not necessarily a bad thing, but what does 6 sessions add to the debate? And then there's a follow-up question that asks, do you think that the rules on referral to the court will reduce the fear of the Commission of de novo review and enable the latter to make referrals, breaking its reluctance in the past? So this last question is in relation to the first question. I think, Frans, if you check that first one, you can also address this one. And also there's a question which is just coming on the seizure of courts, which is also addressed to you, Prof. It's also a bit long. Since you are able to read on your side, you can just read it. So a lot of the questions are addressed to you, Frans. So I guess Satang can start, since she doesn't have a lot that are addressed to her, and then we'll give you a chance to address all the rest which have been raised. Satang?
Yeah, okay. So the question was with regard to the number of the increased number of sessions, ordinary sessions from 2 to 4, and the extraordinary sessions. As I said, I think with regard to the 2020 rules, the extraordinary sessions are not mandatory or compulsory. As I said, the wording was changed. So if the Commission, for instance, deems it's necessary that it actually does need the extraordinary sessions, it can do so. With regard to the ordinary sessions, which were increased from 2 to 4, as I said, it depends on how you say it. I mean, in both cases, on the one hand, as I said, it might be useful, especially considering the fact that when you attend the Commission sessions, everything is like all packed up, especially when states have to present their state reports. Then you have all the special mechanisms and mandates having their presentations and panels and all the other things that actually happens within that particular duration of time. But I think also, as I said, it also does bring into question issues around resources, around time as well, in terms of the number of sessions and whether in any case that might be too much, for instance, with regard to dealing with the work of the Commission, but also, as I said, with regard to this particular platform in terms of civil society participation, because I think that is important. Whether I mean, even with the 2 sessions, for instance, if both sessions are held in Banjul, going to Banjul is, apart from it being problematic in terms of getting there, but also the human resources, the financial bit that is needed for civil society to participate is always an issue for a lot of organizations, even those with observer status. So having 4 sessions might also be a bit too difficult to justify why you're going to Banjul or somewhere else 4 times in a year. But I think, especially in light of the fact that, you know, because of the issue around COVID-19 and the pandemic, now sessions can be held virtually. I mean, it might also be a good way of the Commission trying to cut down costs, especially for the Commission, but also for NGOs in terms of coming in person for the session and rather holding the sessions virtually, which I think might be a better way of doing it, and really creating the platform to address most of the issues that are not usually taken care of because of the shorter duration of time. Yeah. Yes.
Should I go? Okay, thank you for the very interesting questions. If one follows the chat box, question 5, maybe let me try to take that one first. I think the question poses this following issue. In the 2010 rules, in Rule 118, one of the sub-rules made it possible for the Commission to refer cases of massive serious violations to the court. And at least some people argued that those cases of massive serious violations need not be cases that had been formally instituted before the Commission, but it could be cases that the Commission just has evidence and information of, and it can refer those cases. There was some ambiguity, at the very least, I would argue, in the Rule 118 as it was. So the question is whether, if we now look at the new rule, Rule 130, is that a gain or a loss? Because if we look at Rule 130, does it actually exclude this possibility of the Commission referring massive violations outside the ambit of its communications procedure? I think, in my reading, it is quite a narrow formulation, Rule 130 of the 2020 rules, because it says the Commission may, before deciding on the admissibility of a communication submitted under Article 55 of the Charter, decide to refer the case to the court. So that seems to talk to formally instituted communications. And I think that, generally speaking, the complementary role of the Commission vis-à-vis the court could be understood to be one that relates to communications before the Commission and how they would be complemented by the court's enhanced jurisdiction. So perhaps the rules in 2010, in Rule 118.3, the rule about massive violations being referable outside, arguably, the context of communications, that rule, I think, was, in a sense, lawmaking on the part of the Commission. It put something there that was not apparent, and perhaps its omission from the 2020 rules, I think, could be a backward step. One may argue differently, but that is perhaps the most likely outcome. I have another question that speaks to the issue that I argued that delay should be avoided, and some question one, I think the person posing question one suggests that the Commission may actually, if it does not refer the cases decided by itself on the merits in which it has given a recommendation to the states have not complied. That was kind of the main understanding, perhaps by many. Those cases would go to the court. We know that none of those cases were referred by the Commission to the court. The question suggests that perhaps that's not such a bad thing, because isn't that just leading to more delay? If the case goes again to the court, and the understanding is the court will have to deal with this matter de novo, the court will again look at the arguments on the merits, and after some time only come to a conclusion, that exacerbates delay. So perhaps it is better for the Commission to take its own decisions to the political organs and argue for a kind of the binding nature of those Commission decisions. So cut out the court, just take them directly to the political organs. I would say that sounds plausible, but the point is we have not seen much of that kind of acceptance on the part of states that the Commission's findings are to this extent unequivocally binding. We are reminded of that case of Good versus Botswana, some years ago. The government of Botswana quite clearly said that it is not going to comply with that decision. The Commission came out quite clearly. It put in its activity report that steps have to be taken against Botswana. It is non-compliant. So it went to the political organs in that particular case. The political organs predictably did not respond, they did not react, they did not take a particular position. Whether even with the delay, getting a binding judgment under international law of the court creates added weight and pressure on the state, I would still be arguing that yes, it doesn't follow that necessarily just because there's a court judgment there is going to be compliance. But this process of the court getting a judgment, I think we've seen that the states are quite observant of, they're quite reactive to the court's judgments because there's a certain weight that is perhaps attached to those. I refer us also to the rule that talks about this kind of political relationship. Under the rule in the new rules 125 that speaks to implementation, we see there's a rule that says the Commission shall indicate in its activity reports the status of non-compliance, and then it says in the rule 125 sub-rule 8, where the Commission finds that the state party's conduct may raise issues of non-compliance, it may refer the matter to the attention of the AU political organs as provided in rule 137. So it sounds like that's the route the question one suggests. It is just very unfortunate that if you go to rule 137, it is not applicable. So it is an editorial, or is it editorial, or is it deliberate? Because the cross-reference there doesn't make sense, because it speaks to the relationship between the Commission and the Committee on the Rights of the Child. I assume it might be the next rule, 138, because it talks there of the report that the Commission gives to the political organs. The point is that possibility was open. The Commission had to some extent explored it. It was also in Rule 112 in the past with its own problems. So I fully see the argument that I think question one poses, but I think it's still perhaps one can explore both avenues. I think the one neither of the two, the court's binding judgments or the political engagement by the Commission, neither of the two, I suppose, holds promise of necessary success. The last question that I think I'll attach, try to look to, is question 2, which is, just generally speaking, do I think that it's an improvement? The rules are 2020. I think from my statement, it's a general. Excuse me, my pen dropped. It's a generally speaking, it's an improvement. Satang showed some weaknesses. There are certainly some issues. It's not like it's a panacea, I think also in respect of NGOs, I want to just highlight one of my concerns that we have not really talked about, perhaps Rule 72. In the previous rules, clearly, there is a relationship between NGOs and the Commission, and the Commission indicated, that NGOs have to, also comply with their part of the bargain in general terms. But in the new rules, it says the Commission may decide to take measures against NGOs that default on their obligations. And that to me is just, so for example, does it mean that NGOs who don't submit their annual reports as required, and that's the majority of us, sorry to say, that we can selectively be if you like, action can be taken against us under Rule 72. I don't know that obsession with NGOs being disciplined within the African human rights system, I think is in my view not very productive. But generally speaking, yes, I think the rules are an improvement. I can say the question also asked, but what would I have wanted to see in the rules? What perhaps the Centre and others suggest. I would say that many of these suggestions go to the relationship between the court and the Commission. I would have liked to see something like the present Rule 130 sub Rule 1, namely where the Commission can refer cases to the court without dealing with the admissibility or the merits. But I think the criteria should be spelled out very, very clearly. And the criteria should be a case against a state that has a record of non-compliance with the Commission's decisions, where there's some kind of urgency and seriousness. That case, I think the Commission has it's a logical competence to refer that case to the court without breaching the principle of complementarity. We know this is a time in which the states are very sensitive to issues pertaining to access to the court. We know 4 states have withdrawn their declarations of direct access to the African court. And if the Commission, through Rule 130, is being seen to almost circumvent the necessity for making a direct access declaration on the part of the states, because states complaints go to the Commission and directly to the court, I think the Commission must insulate itself against potential criticism that it is becoming a conduit. And one way is to make very clear criteria that are exceptional, but are applied consistently. It's true that the Commission is still the party appearing before the court. Even in those circumstances, the Commission can argue that it is different from an applicant accessing the court directly. It is still the Commission that takes the case to the court in those instances, formally speaking. But if it becomes like a very regular practice, I think the Commission, in the political context in which we find ourselves, should rather have very clear criteria. I think the Commission should still have had the referral to the court on the basis of non-compliance, despite the arguments we talked about now, so that when there is a clear situation where the state has not complied with the Commission's cases, decisions, perhaps even with political pressure being exerted, that there should be almost a default position, like in the Inter-American system, that there should be, after a period of time, there should be a default, that the case would be referred to the court. So I think we should have borrowed from the Inter-American Commission-Court relationship in that respect to clarify that referral would take place. Those are just some of the issues. I would also have liked to see much more clarity about follow-up, about implementation. We see essentially the rule being repeated, in terms of implementation of the decisions of the Commission. What I would have liked to see is maybe an institutional mechanism, like a unit for implementation and follow-up being created in terms of the rules, much more clarity about how implementation and follow-up would be dealt with by the Commission internally through different processes, and more clarity about things like implementation hearings and procedures around implementation hearings that needed to be held. So I think that is an area in which I think the rules could have certainly gone much further than they have up to now. So maybe with those comments, I take a back seat and check what other questions have been posed. Thank you.
Yeah, while we're still on the court discussion, there's a comment that says this person feels that the 2010 rules still maintain status quo in terms of transference of case to the court, and it says that the Commission reluctance to transfer cases to court is officially based on two excuses. The first being the fact that of being understaffed and the financial support to carry out what it takes to build a case. I still don't know how the 2020 rules have addressed that. The Commission is still understaffed as per its last activity report, and the budget seems not to move. And the budget seems not to move either. So thus, for me, this is a status quo, meaning the challenge to transfer cases to the court still remains the same. And in the breadth of budgets, Satang, there's somebody here who is asking, now that we have 4 ordinary sessions and additional extra sessions, it appears that the Commission is almost permanent. So with commissioners who have their own jobs, are they able to accord that? And how are they going to be paid?
Okay,
So
I think mine might be easier whilst Professor Frans is running through the rules. I think in terms of the number of sessions, and I think it's closely linked to the question that I previously answered as well. I mean, we do know that the commissioners' positions are not permanent in the way a lot of us have jobs that are permanent, because they also have their jobs. Some of them are judges in their country, so they have their sort of like full-time jobs in their country of origin, and then they do the commission's work, which is not just coming to the sessions, but also in terms of their different working groups, the special mandates, and all the other things that they do. I don't think, as is rightly mentioned in the question to Professor Frans, especially in terms of budget and so forth, I don't think there is anything regard to paying commissioners permanently. I don't think the commission is quite capable of that. And I think as we mentioned, probably the sentiments behind increasing the number of sessions are actually good, especially in addressing the backlog of the work that the commission does. But it comes with a lot of it has a lot of consequences and a lot of things that needs to be put in place in doing that. And that is why, as I mentioned earlier, I think having the sessions virtually might be the normal in addition to having some few in-person sessions as well, might be the way in terms of addressing some of the budgetary constraints as well as time and so forth. But I don't think there's a clear-cut answer in terms of a payment to the commission, to the commissioners as well, with regard to the increased number of sessions that are highlighted in the new rules of procedure. Prof?
Okay, thank you. The issue of the excuse or the reason that the Commission gives for not being able to take cases, refer cases to the court, being lack of financial resource and expertise and so on. I can just mention at least if I quickly compared Rule 120 in the old rules with 132 in the new rules. In the old rules, the Commission said that, in terms of being represented before the court, it can designate one of or more of its legal officers. So the idea was the Commission would go with 1 or 2 legal officers. In the new rules, there's an addition, and it says and or experts who shall be designated or appointed by the Commission. So I think the Commission has now come to acknowledge at least that it need not be a Commission or a member of the staff, the legal officers, but it could be an outside expert. So I think that shows thinking. It shows a possibility of getting expertise that are outside of that of the Commission to take a case. But your questioner, your point stays, and that is an outside expert will certainly require most likely financial resources. Although perhaps this can be combined with some kind of pro bono register or pro bono system. We would imagine, and we know that there would be many NGOs and others and lawyers associated to these that could be available to do this, maybe without the financial compensation requirement for a lawyer, a high level legal practitioner from a practicing bar. So I think there's thinking that has gone into it, but I think it is not impossible to get these outsiders instructed by the Commission and working with the Commission to take this case further, if that is a genuine concern on the part of the Commission. The question is again about the criteria for referral. Maybe I answered it, but just to make my point perhaps once again, and that is that I think that the possibility of the Commission referring cases after merits and after reparations, it's still there, and I would say that should be a much more almost automatic process after a certain period of time, after non-compliance had been established, that the referral should take place. But again, if one looks at the inter-American system, this evolved over time, and there was an interim phase where a number of criteria were given, and obviously these criteria would include the view of the complainant, but also the effect that the continued non-compliance has on the communities affected, the effect that this has for the jurisprudence of the system. So yeah, I think taking a leaf from the inter-American system there could be useful in that referral, but the referral without considering the case, in other words, before admissibility or merits, I think that referral should be exceptional. It can happen, it should be done for cases where it is clear that there is need for a binding decision on the short term, that this whole route of the Commission, giving, in a sense, the state a chance to comply with a non-binding, if you like, taking that distinction, non-binding finding of the Commission, that is useless for that state, because that state has a reputation of never contemplating compliance with the Commission. So, I mean, a number of these states have not ratified the court protocol. So the most clear examples of those, let's say Eritrea, if I may use it as an example of a number of cases where there is consistent non-compliance. Eritrea is not a state party to the court, so it would not work. But if in another case this arises, I think that should be one of the criteria being used for that relatively exceptional measure of immediately the referring the cases to the court.
Prof, there's also a question to you that asks, what difference does it make in the choice of the verb chosen by the Commission and 3 verbs it chose in 2010 rules, the 3 verbs being submit, refer, and seize? Can we say that aligning the wording of verb with the Article 5.1 of the Court Protocol will be a sign or willingness to improve the complementarity between the 2 bodies?
Okay, I've not really. Let's look at Article 5 of the Court Protocol, which says, the following are entitled to submit cases to the court, which includes the Commission, right? So the word submit is used in that context, and then we have the word being used in the new Rule 130 is the rule, the word verb seize, right? Seizure okay, the heading of Rule 130 is seizure, but then if one reads the rule, it says the Commission may, before deciding the admissibility, decide that the communication should be referred to the court, provided the respondent state has ratified the protocol. So, in those 2 examples, we have 3 words, right? Submit, refer, and seize. Personally, I think they all amount essentially to the same, that it would be a matter that is before the Commission that ends up being considered by the court. So whether it is the verb is refer, submit, or to seize the court, I think that nomenclature can be perhaps obfuscating and a bit confusing, but I don't think that can turn a particular understanding of the competences of the Commission in any of these respects. I can just see what the wording was in Rule 118 in the old rules. I mean, when we talked, it was a heading again was seizure, of the court. And then in each of the provisions, it talked about submit, and then even in the next one, refer. So I don't know. I think it is not very deliberate, because if the heading is seizure and the provisions talk of submit and refer, I think maybe seizure is just more like an umbrella term, and then these other terms fit into that, but they do not, I think, denote anything very specific.
Satang, on national human rights institutions, there's a comment here that says, in order to address the implementation challenge, the Commission could have identified domestic courts amongst its implementing partners, in addition to national human rights institutions, and set a focal point within the Secretariat as a mechanism. What are your thoughts on that?
I think the first part, I'll leave that to Professor Frans. In terms of utilizing the domestic courts, but I think for national human rights institutions, and I think Professor Frans also, spoke about this idea that he might have wanted to see sort of like a focal point or a unit set up within the Secretariat in terms of implementation as well. I do think, especially in terms of enhancing the role of national human rights institutions as well as NGOs, can really serve as a way of advocacy and engagement in terms of follow-up with states regarding the implementation challenge, regarding decisions that have been taken, in terms of coming up with really strategies in terms of engagement with state parties and so forth. But I think the reality, and even from this conversation as well as debate, is that the implementation challenge continues to be a key stumbling block in terms of processes of the African Commission, especially in terms of the realization of human rights generally, when states are found to have violated the fundamental human rights of their citizens and so forth. So I do think that in terms of enhancement of national human rights institutions, who are really now playing a critical role in different African countries, as well as civil society organizations coming up with advocacy and engagement mechanisms and strategies in terms of pushing for their own state parties, as well as amplifying the voice of civil society to push for implementation of these decisions. I think there's a way in for that. In terms of, as I said, in terms of domestic courts, I'll leave Professor Frans to address that.
Yeah, I think, thank you, Satang. We found that African domestic courts have placed the reliance on the Commission's jurisprudence as an interpretive source, right? So they refer to it in order to interpret the national constitution and so on. We don't have, I think, examples of the Commission's finding in respect of a particular case being domesticated through, domestic courts. In other words, like an enforcement of foreign judgments procedure. We have, in a sense, some South African jurisprudence on that, but that relates to other judicial tribunals. So that's perhaps another argument that the African courts' judgments, which are unequivocally, judicial and legally binding in nature, we can make an argument that those judgments, I think, can be regarded as foreign judgments that could be domestically enforced, in other words, by domestic courts. I mean, there is an argument to be constructed, because usually a foreign judgment is a judgment of another national jurisdiction that needs to be enforced in a different country. Here it is an international court, the African Union's court, that judgment needs to be enforced. But I think that argument can be made. But it is much more difficult, we'll all agree, to make that argument when it comes to the Commission's recommendations, findings, which are not unequivocally binding as much as we would like to argue. It is going to be hard to argue that the Commission's findings can be enforced as they are by domestic courts. And one of the reasons would be the lack of clarity about the judicial nature of the Commission's findings, I think.
I just wanted to add, there's I think an additional question with regard to the NHRI's, I think Rule 82 sub 4. Person say requires the Commission to send observers concluding. Yeah, as I was saying, I think generally we do know that the national human rights institutions really can play a critical role in terms of ensuring and pushing for implementation, not just with regard to decisions and decisions and findings, but I think more importantly as well in terms of concluding observations on state reports, because I think generally what we found is that with regard to the concluding observations in most instances, for you have the concluding observations which sometimes comes very late, but which in most cases are actually not implemented by state parties. So national human rights institutions do have that particular position in the different states in terms of pushing for, as I mentioned before, in terms of implementing the findings and pushing for that, but most importantly in terms of the concluding observations. And I think in addition to civil society organizations, as I said, I think it's important, especially in terms of civil society advocacy and engagement with, with concluding observations on state parties and holding states accountable to the concluding observations in prior state reports. And I think, for instance, with from the Center, the Women Rights Unit, for instance, have been doing work around that, especially with regard to Nigeria, South Africa, in terms of concluding observations on women rights issues. And I think these might be strategies and measures in which NGOs, for instance, can think around in terms of how they can engage state parties, how they can engage relevant state actors in terms of implementing concluding observations and not just findings and so forth. Yeah.
If I may, just because we brought state reporting in, I would like to just point to some small additional, I don't know, improvements. If you look, for example, at the 2010 rules, they obviously said that the Commission should adopt concluding observations after examining state reports. But if you look at the new rules, Rule 82, it puts a timeline. It says the Commission should do it at the next session, and it must not be longer than 2 sessions after the report was examined that the concluding observations are adopted. And I think for those of us who follow the Commission's work, we know that was often a problem, that state is heard, examination of the state report takes place, but one doesn't see the concluding observations coming out for sessions and sessions on end. So at least I think the Commission is holding itself a little bit, or potentially it creates a framework to be held to account more clearly. But in general terms, I'd like to say, Marie, that in preparation for this talk, I read a little bit through the old rules, which one doesn't do usually, for your leisure. And my conclusion is that there was already a lot in the old rules, in terms of, for example, if you look at concluding observations, the Commission was supposed to communicate this, put it on their website immediately or after they've been made public. That did not happen. Perhaps, even if we say there are improvements in the new rules, my sense is that it ultimately depends on how these rules are actually implemented, right? It's perhaps obvious, but there had been good things in the old rules that have been passed the Commission by and were not implemented effectively. I think the message to me, looking through these 2 sets of rules, really is that perhaps it bears knowing quite clearly what these rules say and holding the Commission more vocally and deliberately accountable, and looking out for these rules and how they are actually implemented.
So we are almost half an hour before the session ends, and I would like to bring attention to the chat box where I've shared a link on work that Satang had done for the CIAC around analyzing the 2020 rules of procedure. And that article is available both in English and French. I will share the French version shortly. And there was a request from Equality Now to participate in their survey in which they're collecting comments around the 2020 ROPs. So before we close, I would like to invite comments from the floor. Got muted, yeah. So yeah, just 2 brief comments, and then we'll take it back to Satang and Frans for closing remarks.
Am I unmuted?
Yes, you are. Please go ahead.
Good afternoon, Professor Frans. This is Dr. Ogunade Feyi. And Satang, good afternoon. By the way, Satang, I read your brilliant article on the rules. Absolutely wonderful. Thank you very much for the insight. Professor Frans, particularly this question is for you, or this commentary is for you particularly. I have always wondered, even when I worked at the commission, what the term, a lot of NGOs will tell you about the independence of the commission, the independence of the commission. And I agree with them. I support the independence of the commission fully, but I've never been able to understand really what it means. What do they really want from the commission in terms of independence? We've never been able to dilute. As an intellectual discussion, I keep asking, what exactly do you mean by an independent commission? And in a way, many of us disagree. Will disagree what the Executive Council said, that you have functional independence. And when you look at it very carefully, I think there's merit in what the policy organ is saying, but because you need to go back to the history of the commission. And Professor Frans touched on it earlier, that when the commission started, remember, those were the days in the 1950s when the conversation started. Many of us were not born. Satang was certainly, I'm sure Satang's parents were not born. and when the conversation started about the African Commission and dragging on to the 60s and 70s, those were the days of coup d'etats, one-party states. Idi Amin was in power at one point in time, became the Secretary General of the OAU. So the commission came from the cauldron as an afterthought. Okay, you people want you want a commission to promote and protect human rights, you can have one. And so they just threw it. That was one of the reasons why you never found the commission as an independent organ within the structures, even when it metamorphosed into the AU. Our state managers and state leaders never thought of it as anything but, okay, as an afterthought. You want something to protect human rights, you can have one. And they refused to fund it. I mean, Professor Frans knows the history backward. Even when people like us joined the commission, many of the staff I met there were funded by NGOs, international NGOs from outside the continent. So now, in terms of independence, the truth of the matter is, in a way, we have to give credence to Madam Mary Maboreke, the previous secretary, for ensuring that even the AU had to acknowledge that we were an organ. But there's always a contradiction. Are we an organ? Are we a treaty body? How do you reconcile the two and all of that? So I've always wondered, what really do we mean by independence? And when I was there, in all honesty, as a matter of fact, myself and Dr. Eno, we were the first people who drafted an argument supporting the CAL application in 2008. We supported it and we saw it through until most of us left the African Commission. That was the only problem in terms of where our independence was really challenged. But all the reports we wrote, all the cases, I have never witnessed wherein the policy organs will say, change this letter, change this one. In my time, in Dr. Eno's time, it's never happened. I've never seen it. So the challenge came when the CAL application came, and I completely understand it. And we supported the CAL application. Unfortunately, we are where we are now. But I've always wondered, what is it exactly that we as civil society now want in terms of independence? Because the truth of the matter is the commission able, really, practically, to be independent? And I agree with Professor Frans. I think it's a philosophical position of an independent mind. In other words, when you write your reports, nobody should tamper with it. When you make judgments, nobody should tamper with it. And I understand the whole concept of the word considered. But that was the reason why in another conversation, in one of the Zoom meetings, I was asking myself and other participants, what exactly do we need to put? If we remove the word considered, what else should we put in there? And by and large, apart if you remove the car incident, the commission has been able to maintain fairly okay its independence in the manner in which we, as legal scholars, in the manner in which we want to see. So I suppose the contribution I'm making is that aren't we, even though I would love to see an independent commission, but maybe is autonomy not the right word instead of independence? Thanks.
Frans, let's take another comment before you respond to Dr. Faye. Any other voice? Going once, going twice, going thrice. Okay, so Frans, you can respond to Dr. Faye and then we will conclude the session. We'll each make your last remarks too.
Thank you very much, Dr. Faye. Yes, I think you sketched a conundrum, and you know, I suppose I did also side with what you say. I think there are three terms here: independence, autonomy, and also maybe impartiality. I think what we want the commission to be is certainly it must be autonomous. For me, it's like the commission, when it exercises its discretion, it must do it on the basis of its mandate to promote and protect human rights. So that is the autonomy. The autonomy is located in a normative framework. You cannot interfere with that. So that clearly is what happened here. So what happened when the Executive Council told the Commission that its interpretation of its own framework needs to be different from what it was. So it is unequivocally an issue of autonomy being eroded there. Then there's the issue of impartiality. I think it's just as important, but that relates to the particular case, right? So now if there is a particular case before the Commission with particular complainants and a particular issue, then you know, the Commission and the particular members must not be biased. They must not have a predilection for one or the other. And that clearly needs to be, you know, regulated, and that is. But that's, you know, a matter that, in my view, arises from case to case. Then the last issue, I think, is what you mentioned, independence. Independence is a big word, right? We take it when states, rid themselves of the shackles of colonialism, they become independent. So it is a huge concept in my view, right? The invocation of independence for me comes from there, but it also has other manifestations. Independence here, I think, essentially when civil society uses the word, they mean there shouldn't be the strings of the commission should not be pulled by entities, power brokers, which are not the commission itself, right? So the commission's agenda cannot be dictated by another agenda. So there's a link with autonomy, but I think for me autonomy is much more clear, and I would agree with you, and therefore I find it useful and fortunate that the rules in Rule 3 talk about autonomy, and it leaves the issue of independence out. Because as you say, if we have to ask ourselves, what does dependence mean? In a sense, if it is a monetary issue, there is a certain element of dependence by the Commission on the resources of the African Union. It's just undeniable. But then we are starting to define independence as functional and institutional and so on. It's a minefield. It needs to be addressed. I'm not trying to evade it completely, but I think you're right. Let's frame our language around autonomy in the first place, and give our own understanding of independence when we use that word, which is valid and is also important, but it can be confusing if one doesn't clarify what one means. So Thank you very much for the question and for the questions in the chat box. I really found it very, very invigorating and interesting. You know, it drives one back to read the small differences between the two sets of rules. And I think my overriding conclusion is ultimately let us take the rules seriously and make them work for us, because I think whether there are small differences that improve or deteriorate our own protection and standards, that's one thing, but these rules are also malleable and in the hands of those who really are bona fide and want to make things work. You know, we can advance the cause of human rights in Africa. Thanks.
Satang, final comments? Satang, you're muted. Tiffany, please help unmute Satang.
Thank you. For some reason, I'm pressing the unmute, but it's not unmuting anyway. No, I think Professor Frans wrapped it very nicely, and I just wanted to say, just especially in terms of the role of civil society organizations and NGOs generally, that, you know, we know the current climate, especially in terms of the shrinking civic spaces in our various countries as well, and really the African Commission and its procedures and processes does provide a platform for us to push for the realization of the human rights of people in Africa. And I think it is important, including this platform and other platforms, in terms of thinking through, in terms of strategizing how we can further engage. But I think most importantly, especially in terms of the rules, as Prof said, how do we make it work for us? Because I think that's the most important thing, especially when you compare it to the 2010 rules, that, you know, it wasn't all bad, that it had a lot of things, but implementation is really a problem everywhere. And this is really where NGOs and civil society organizations can really come in terms of how they can push for implementation of not just findings and decisions, but also in terms of pushing for implementation of concluding observations, but also in terms of even playing their own role by submitting shadow reports or complementary reports to the state reports and the other processes that are available for civil society engagement with the African Commission. Thank you for this platform. And I mean, this is an ongoing conversation that I'm sure will continue. Thanks.
Yes, it is an ongoing conversation, and let's meet tomorrow at around this time, and we'll still have some more conversation around the independence of the Commission, and it's going to be a dialogue between Palu and Sahel, hosted by the CIAC, and we'll be contrasting experiences within the African human rights system and the American human rights system as it pertains to independence of regional human rights systems. So with that, I would like to say thank you to all the participants, and thank you to our panelists. It was such an insightful session, and yeah, have a great day or evening, wherever you are. Bye. Yeah. How do I?